When you hear the word kidnapping, you immediately think of a stranger in a van, maybe a ransom note.
Right, the Hollywood version.
Yeah, exactly. You don't picture a dad who just won't bring the kids home after his weekend, or a maid offering to take some teenagers to the movies.
But that's exactly what we're looking at today, this really messy gray area where a family problem or just a bad decision suddenly crosses over into criminal law.
We are diving into Articles 270 and 271 of the Penal Code, and our whole mission here is to figure out where the law draws that line. The line between, say, a bad custody dispute, a rebellious kid, and an actual crime.
And it is a surprisingly thin line. It all seems to hinge on this one core idea, protecting what the law calls the filial relationship.
Okay, what does that mean?
It means the law is, well, it's less concerned with where the child physically is and more concerned with who has the right to influence them.
Got it. Okay, let's start with Article 270. It's titled Kidnapping and Failure to Return a Minor, which is the confusing title.
It is, because it's not really about abduction. The key element here is trust. Or a breach of trust.
So you mean entrusted custody?
Exactly. The law applies when a minor was given to you totally lawfully. You could be a guardian, a relative, a babysitter, and then you just refuse to give them back.
So it's not a snatch and grab. It's more like a breach of contract that becomes a crime.
A breach of trust. And the law takes that very, very seriously. If it's a neighbor or a babysitter who does this, the penalty is reclusion perpetua.
Which is basically life in prison. That's huge.
Yeah.
But then I saw this exception for parents, and it almost seems like a double standard.
It's what some call the parental paradox. The penalty it falls off a cliff.
From life in prison down to what?
Down to arresto mayor, which is just 1 to 6 months. Or a fine of, historically, like 300 pesos.
That's not even a slap on the wrist. Why is the gap so massive?
Well, the law sort of assumes a parent is acting out of a misguided instinct, love, maybe desperation, not pure criminal malice like a kidnapper seeking ransom.
So they don't want to treat a distraught parent the same as a hardened criminal.
Pretty much. Though, the Supreme Court has wrestled with this. In People v. Joe, they even suggested this whole article might be redundant now.
A legal gray area, then.
A big one.
Okay, so that's keeping a child. Let's pivot to Article 271, inducing a minor to abandon home. This feels different. We're moving from refusal to, active persuasion.
Right. This is all about influence. You don't need any custody. You just have to convince a minor to leave their home.
This is the one that worries me. I mean, if I tell my friend's kid, hey, your parents are being way too strict, just come crash at my place, have I just committed a crime?
Well, that would depend on what the courts call ascendancy. It's about the power dynamic. The case People v. Pullum is the perfect example.
This is the maid in the movies case, right?
That's the one.
So the facts are, a 19-year-old maid tells two 14-year-olds that Manila has better movies and offers to pay their way to go there. And they go with her.
And the court said, not a crime. They acquitted her. They found she had no moral ascendancy over the girls. I mean, she was barely older than them.
So the court's view is that the girls weren't really manipulated.
Exactly. They said the girls were likely moved by a spirit of restlessness and adventure. Just teenagers being teenagers, not victims of inducement.
So if the kid has agency and you aren't really dominating them, it's just bad judgment, not a felony.
Right. Now compare that to People v. Apolinar.
A whole different situation. There, a woman promises a 12-year-old girl some new clothes, lures her away, and then threatens to kill her if she makes a sound.
A clear threat. But the girl actually managed to run away before they got very far.
And the defense argued that since she never successfully abandoned home, no crime was actually committed.
The court completely rejected that. They said the crime is the act of inducement itself. The moment you act with that malicious intent to break the family bond, you've crossed the line.
Whether you succeed or not is irrelevant.
Totally irrelevant. Because in that second case, the intent was to sever that filial bond. In the first case, with the maid, it was just an ill-advised trip to the movies.
So the law is really protecting the home, the family unit, as an institution.
Precisely. It's drawing a line between someone who is just a bad influence and someone who is actively trying to dismantle a family.
Which leaves us with a really tricky question for everyone to think about. If the crime is complete with just the act of persuasion, even if the child doesn't leave, where exactly is the line between giving, say, valid advice to a kid in a bad home and committing criminal inducement?
That is a line you probably don't want to get near without calling a lawyer first.
Thanks for deep diving with us. We'll see you on the next one.